Hi there, I'm Savannah Mexto with Mannor Law Group, welcoming you to another Webinar Wednesday with esteemed elder law and estate planning attorney, Robert Mannor. This week, attorney Bob Mannor will be discussing revocable living trusts and why they can be one of the best planning options today that help families tomorrow. Before I pass the mic to Bob, I'd like to cover a few housekeeping details. First, even though Bob is an attorney, today's webinar will not give specific legal advice. If you have a question about your unique situation, please contact us after the webinar. Also, if you have a general question during today's presentation, please use the question box. We will save time to review questions during the webinar. If for some reason we don't get to your question, we will contact you after the presentation. And today's presentation will be recorded. The replay will be sent out tomorrow so that you can share it with family, friends, or anyone who you think could benefit from hearing this information. Now, why should you listen to what the folks at Mannor Law Group have to say? First, note that we're a nationally recognized and respected elder law and estate planning firm. All three of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Attorney Bob Mannor is nationally board certified as an elder law attorney by the National Elder Law Foundation. He's one of only 19 attorneys in Michigan to achieve this designation. Bob is also a leader among elder law attorneys in Michigan. He is currently chair-elect of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys, Michigan chapter. Lastly, Mannor Law Group has been honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row. Now, without further ado, I'd like to welcome attorney Bob Mannor.
Hey folks, this is always a great topic, and we're going to keep it pretty straightforward today. We're going to talk about the 3 reasons why a revocable trust actually saves you money, and I'm going to kind of put that in context of what I mean, because sometimes when we look at it and we look at the legal fees, the cost of doing different types of legal planning, people will look at a will-based plan versus a trust-based plan. So do I need a will or do I need a trust? And of course, one of the factors that's going to go into that is going to be, well, how much does it cost, right? Of course, we're always going to have that as a consideration. And what often we'll see, and what is certainly true in our office, is it costs less to do a will-based plan than it does to do a trust-based plan, but it actually costs more in the long run. So it costs less in legal fees up front to a will-based plan, but it's going to cost more in the long run in a bunch of ways. So in reality, the trust-based plan is often the best financial plan, the most cost-saving plan, even though it costs a little bit more upfront. You know, sometimes those are the things that are truth. That sometimes it's we have to pay a little bit more upfront in order to save money, both in the short run and the long run. In other words, it might not take long for it to actually pay off and make it less expensive. All right, so the first reason that we have as to why it saves money is it's designed to stay out of probate court. This is the one that most people understand and know, or one of the main reasons why people actually do trust. So when we come in, folks come in, it's almost always to say, hey, I want to stay out of probate. I think that's good. I think that's wise. It's not that there's something specifically wrong with probate, but it's one more government process, one more government system, one more government intrusion, so to speak, that we don't need if we've got people that we love and we trust. And if you've heard me speak before, I often will talk about that. If you've got nobody that you love and you trust, then we're probably not going to, have as many planning options. So it's easier to plan when we have people that we love and we trust. Okay, and so the court system is kind of designed to say, well, we're not sure if they loved them, and we're not sure if we definitely don't think that they trusted them. That the court system is definitely designed that way, to have those checks and balances to say we really can't trust anybody. Well, as a result of that, there's a lot more red tape and a lot more hassle, a lot more cost involved in going through the probate system. This is true during your lifetime if you got sick, or after your death to settle your estate. A lot of the probate attorneys don't look at it the way, I know probate judges don't necessarily look at it that way, but I've sat in many, many probate courts over the years and just listened to all the stories, and the judge has to be cautious. The judge has to be suspicious, because They don't know what you know. They don't know what your family's like. And even if the family all comes in together holding hands, the judges automatically has to be a bit suspicious of, are these people going to do the right thing? Can they be trustworthy? So are we going to have to issue a bond, a very expensive bond that is very difficult to get, so that we might appoint a family member to be in charge, but now they have to pay a bond in order to stay in charge? Or we put restricted accounts, meaning we have to go back to the court every time that we want to do something beyond the monthly bills. Or when we want to settle things, or we want to sell the house or things like that, would we have to go back to the court? That's going to depend on each individual situation, each individual judge, each individual county court process. But the bottom line is the process is designed because you can't necessarily trust them. They don't know what your relationship was. They can't know what that relationship was. Well, hopefully you do. Hopefully you have people that you love and you trust. And we can avoid that government intrusion. We can avoid that government process, that court system process, the red tape, the hassle, the cost, the expense, all the rest of that, by empowering the people that we love and trust. Not necessarily so that they can take over now or during your lifetime, but so that they can step in when they're called upon, when they're needed, okay? And that's the idea of avoiding probate. So I don't want to give the impression that probate's this terrible, awful thing. Of course, there's a need for probate court. But with many of the families I work with, we could just as well and much easier have the family do it without having to go through that court system, without going through that probate system. The best way of doing that is with a revocable trust. Why? So first of all, before I get too far, I want to make sure that we're all on the same page, because we throw out these terms and sometimes they can get kind of confusing about revocable trust or living trust. Sometimes we hear this word living will, which is a completely separate thing, okay? So let's define these words that sometimes we hear say, and you'll hear me say. Revocable living trust. Revocable, changeable, you're in charge, you're in complete control, you've created this, that means you can change your mind whenever you want. That's the idea of a revocable trust. You can change it, you can edit it, you have complete control over it. No one else other than you has control. That's a revocable trust. Revocable living trust. What is living? It means it was created during your lifetime. Sometimes it's not quite so complicated. Living trust means it was created during your lifetime. And the alternative to a living trust is what they call a testamentary trust. A testamentary trust is one trust that's created after your death, typically created by the probate court, okay, on your behalf. But the living trust is one that you create. It exists during your lifetime. You set out the rules during your lifetime. It has assets that it manages during your lifetime. You still can change it and you still have complete control over it, but it's a living trust. You've made those decisions rather than relying on a court or having it done after your death. That's the opposite of a living trust, as a testamentary trust. All right, so those three words again: revocable, changeable, living, done during your lifetime. Last word, trust. What is a trust? It's just a contract. That's really all the trust is during your lifetime. It takes on a different form after you die. Then it becomes irrevocable and has its own tax ID number and things like that. But during your lifetime, it's just a contract that you have with the people that you love and trust. That's why I talk about you have to have people that you love and trust to make this work in its best form, because it's a contract you have with them. It's a contract you have with the people that are important to you, that you love and that you trust, so that you can set them up to say, hey, if I'm ever too sick to get to the bank and pay my bills, if I'm on vacation for an extended vacation and I want somebody to pay my bills for me, if I die and I want somebody to settle my estate for me and do it the way that I say that I want it to be done, then we need a contract with them that says, here's the rules. Here's the rules of the contract when I'm alive and well, if I get sick, and after I die. And I'm empowering those people that I love and trust to be able to act on this contract without having to go to court, without having to get a letter of authority from the probate court or going through any process through the probate court. So that's the first way that it saves money. is to keep it out of that court process. You're empowering the people that you love and trust to follow your wishes. And it's a contract. A lot of people say, well, isn't that a will? What does a will do? What last will and testament, what does a will do? A will has to go through probate court. A will that has zero authority. You're not empowering. What you're doing is you're giving instructions to the probate court, and the probate court gives the authority to the person that you've appointed, hopefully the person that you've appointed. But the idea is that the will itself doesn't give authority, doesn't grant authority without a probate order. A will is useless without a probate order, or what's called a letter of authority through the probate court. You cannot take a will to the bank and get access to the account. You cannot take a will to the realtor and sell the house. You have to get a letter of authority first. With the trust, it's the opposite. The trust itself empowers the people that we love and trust to do the things that we need them to do when they need to do it. So what's the rule going to be when you're alive and well? You can do whatever you want. They don't have to be involved at that time. They're kind of standing in the wings as a backup, right? So that's the idea. I also threw out a word that I wanted to clarify that people get confused all the time. They'll often say, hey, yeah, I have a living will, and they're actually thinking or meaning that they have a trust. A living will is actually a healthcare document of all things. I don't know why they make all of these names sound so familiar, but a living will, the legal document of a living will, is a healthcare document. It's not a trust, it's not a will. So it's called a living will, which sounds like a living trust, and a living will that sounds like a last will and testament, and it's not either of those things. A living will is actually a healthcare document to say what you want in the event of a incapacity or life support or those types of things. All right, what's the second reason why the trust saves money? So the second reason why the trust saves money is that it makes it easier for the family to help during lifetime. Now, I'll tell you this, that so many times that the reason why people decide that they want to get a trust is that first reason. They can see it. It's very clear that it's going to save money by empowering your family, by empowering the loved ones, by empowering the people that you love and trust without having to go through a court process. That's very understandable and intuitive, right? But to me, in my practice, and I've been doing this for 25 years now, in my practice, this is more important than that first reason. And I'm very, very serious about it. I'm convinced of it over and over again through real life helping families through these types of things. Because one of the things that comes up for most of us is that there's going to be a period of time before we die where we need other people to help out with either paying our bills or temporarily managing things for us or helping us make decisions or balancing our checkbook or just being involved at some level. Now, a lot of us that are younger and healthy don't like thinking about that, right? I'm not that young, but the idea is I don't like thinking about me never being, being at a point that I'm not completely in charge of everything. But the reality of human life is, especially these days, that most of us are going to face that period of time. I think a lot of us kind of imagine that we're going to be in charge, we're going to die with our boots on, we're going to have complete control until the second that we die. That's certainly a possibility, but it's highly unlikely. Most of the time, there's some period of time, whether it's a day or a week or 3 years or 10 years, that we need the assistance of somebody that we love and trust, or worse, somebody appointed by a court to help us make decisions, to make decisions for us, to make sure our bills get paid. I know this is not a topic that people like to talk about. People want to imagine that they're going to have full control and full capacity for the rest of their life. We know that that's not true for most people. We know that. And we could put blinders on and say, well, that may happen to my brother or my uncle, or that may happen to my neighbor, but that's not going to happen to me. I got my mind about me. Honestly, that makes it worse, frankly. For those people that are so stubborn about it, that says this could never happen to me, often it's going to be harder for them because it could get to the point where you're not able to, and a court has to step in. So we got, my advice, my strong advice is that we got to be prepared for that. God forbid, hope it never happens, right? Hopefully you can have complete mental and physical capabilities until the second of your death. but we got to prepare in case that's not true. And so this definitely saves money from the standpoint of not having not having to go into court and get a guardianship, not having to go into court and get a conservatorship, or just from the standpoint that we now have a trust, remember, as a contract. Sometimes we also call it a master plan. The trust says, okay, here's what's going to happen with everything. Here's my wishes. Here's what I want to make sure. Here's who I trust to be able to pay my bills for me. Here's the limits of their authority. You know, they can't just go take the money and do whatever they want with it. We got to give them instructions. That's what the contract's for, to give them instructions. And to me, this is just as important. So sometimes I'll phrase this to say, okay, a lot of people go to their lawyer to talk about what happens when I die. That's what you go to a lawyer for usually, to get your will or trust or things like that. I think just as important, and I think probably more important, is what happens before that. What happens if, sometimes I'll say, what happens if you don't die? And what I mean by that, because we're all going to die, but what happens if you get to the point where you need help, you need assistance, and you're not dead yet? Then that's actually often a bigger struggle, a bigger crisis, more difficult for the family, not just emotionally, but legally more difficult for the family, because it's now we've got bills to pay, we've got things that have to be done, and sometimes it has to be done very quickly, and we got decisions to make, and hopefully we have that in place. And the idea of the trust, and we're going to talk about some other legal documents that help with this too, but the trust is sort of the foundational document that helps keep everything in where we have a plan for it, we're organized. One of the things I didn't put on here as a cost saving thing, but it really is a trust forces you to be organized. Because as hopefully if you've come into our office, or once you come to into our office, you'll understand that the way a trust works is we have to make sure we've identified all of the assets, and then over the years we have a way of kind of keeping track of those assets. That, for so many folks, so many families, that's a big deal to get that organization in place, and that saves a ton of money, because by the time you get sick or by the time you die, if the family doesn't know what's going on, and there's accounts over here and there's accounts over here, we got to go to the safety deposit box for this form, and there's savings bonds over here, and there's money stored up in the house somewhere, and there's life insurance, and it's all over the place, and the family's just tearing their hair out saying, okay, how do I get all this organized? Well, why not we organize that during your lifetime? Why not we not put them through that and actually get everything organized? And that's what one of the things that the trust process does, is it forces us to get organized and make it so that it's going to be clearer for your family to be able to say, okay, well, here's where everything is, okay, and here's how we access it, and here's the legal authorities that we have for it. So very, very important. The third cost savings that we have is going to be, it's adaptable. This is really, really important. And one of the things I've been saying a lot lately, and this is something that was sort of a light bulb a few years ago, because I've always known these things, but it was hard to articulate, or it never actually occurred to me to articulate. Why is it so important to have a thorough plan? And not just a plan that says, oh, you know, I got a beneficiary designation on that, or I'm sure it'll be fine, or this is what I want, and they all know what I want. It doesn't matter that we don't have anything in writing, or that we don't have a real legal plan, because the family knows what I want. Well, it doesn't work that way. You might think the family knows what you want. Doesn't work that way unless we have a legal plan to make sure those things are going to happen. Okay, and so one of the things that's very important, and one of the realizations I had of a way of articulating this, is we're planning for something that we know very little about. So what are we planning for? We're planning for two things. We're planning if you get very sick and need help because you're too sick to manage it yourself, and we're planning for your death. So we know that part, but what don't we know? We don't know when you're going to die or when you're going to get sick. We don't know who's alive and who's there to help you. We don't know how much money you had and where it is and how it's titled. We don't know what assets you have, you know, because this is in the future. We don't know when you died. We don't know when you got sick. This is in the future. We don't know what happens between now and 20 years from now, and now and 40 years from now. We don't know how much money you had. We don't know what type of money, what type of accounts it is, what the law is. We don't know what the law is at that time. We don't know if your kids are alive. We don't know if maybe it's the grandkids or nieces and nephews that are involved. We don't know any of this. And so that's why it's so important not to plan based on if nothing changes and I died tomorrow, everything will be okay because I got beneficiary designations, or I got a will, or I've got a deed, or whatever it is. Those aren't adaptable. Usually those are not precise enough, and not only not precise, but they're not thorough enough. So usually we forget about something when we're trying to do piecemeal planning like that. But the reality is that it's more than just that, because things are gonna change. Time's gonna go by. And so if you have a plan that says, well, I've got a plan for my house, and I got a plan for that life insurance, and I got, savings bonds that have the kids' names on them, whatever, we don't know that those kids are alive when you die. We don't know when you're gonna die. We don't know how much money you have. We may have sold those savings bonds. We don't know this stuff yet. And so it's so much better and so much easier for your family, and easier for you, and easier for you to keep track of, to have a plan that's adaptable. A plan like a trust that says, well, this is what's going to happen if my daughter dies before me. This is what's going to happen if my executor isn't around. This is what's going to happen if my executor is too sick. So I appoint somebody, I appoint my spouse as my executor, I appoint my son or my daughter as my executor or trustee, or all the different titles that they might have, and they're too sick. They got sick before you, or they got sick after you, but they're not able to manage it. What's the next in line? The idea of the trust is it's designed to kind of think of everything. I have a quick example that I'll give you. A few years ago, I had a family come in, and when they called the office, it was clear that they were kind of upset about something. And they talked to my assistant, and they said, we just need to come in and see Bob. We have some changes to our trust. And usually we try to get some information over the phone just to gather that information and have me prepared for that meeting so that I know what I'm walking into and what types of changes we're looking at. But in this particular case, it was clear that they were upset and they were having a hard time talking about it. And so they said, we appreciate you trying to get this information, but can we just have a meeting with Bob, and we just want to sit down with them? And of course, my assistant said, sure, that's fine. We usually try to gather this information so we can get Bob prepared, but if this is much more comfortable for you, then we can do that. So they came in and they sat down, and they said, well, this is really terrible, but our granddaughter is going through this major illness, and it's really terrible, and it's very bad, and we need to make sure there's provisions in here for the grandchild, because she's probably going to need to qualify for benefits, for medical benefits, and maybe disability benefits, because this illness is so bad that she's not likely to ever be able to work, or those types of things. And she's just a young girl. She's 16 years old or something like that. And I said, okay, I understand. You're absolutely right. We do need to make sure there's a plan for that. So I took their documents and I started looking through it, and I said, oh, well, we've already covered that. And they looked at me kind of shocked, and they said, well, what do you mean we've already covered that? How could you have possibly known that our granddaughter would get so sick and have this illness and have this need? And I say, well, we kind of try to think of everything. And we had to have contingencies and planning in there for everything, to say, well, what if? Well, what if this? What if somebody gets sick? What if somebody dies before we thought they were going to? What if people die in the wrong order? What if? And that's where a trust can really save you money for two reasons. Number one is we've already kind of planned out all those things that we don't do in a will. Those things aren't usually in a will. And secondly, it definitely can't be done through beneficiary designations, and definitely can't be done through a deed designation. And so the second thing is, when we do need to make changes to the trust, it's a relatively straightforward process. You come in, we make the changes, you sign off on the changes. We have a process for it to make it a relatively straightforward process and make it continue to be easy. One of the things, I'll just, as an aside, point this out, that most lawyers have what I consider a rather old-fashioned way of changing or amending their trust. And I'll be honest with you, this is just my opinion, but I think my way is much better. And I'll give you my way, meaning my firm's way, is much better. So most lawyers, when they make a change of trust, they'll do an amendment to a trust. Here's the problem I see with an amendment to a trust. So now we have the original trust document, whatever that is. We got all these pages of a trust document. And then we have a completely separate document that amends that first document. And then you come in for a second amendment, and now we have a third document that changes the first two documents. And you come in with a fourth document. Now we have a fourth document that changes the first, second, and third, and document, and goes on and on. I've had somebody come in one time, they had 10 amendments, and when they came in, they only had a few of them with them. I can't read that legal document without every single amendment, and it's crazy because now it's that's me pulling my hair out saying, okay, I've got to put these pieces back together because now there's 10 documents that tell us what one legal document is supposed to say. So we don't do, we typically, every once in a while we do for a very special reason, but typically we don't do just a new document amendment. We amend it within the original document. So when you come in, we do an amendment. There's a thing called a restatement, which is also a form of an amendment, where we restate the document as a whole with the changes. That way, then we don't have to worry about losing Amendment 3 or losing Amendment 2, and we don't have to drive the family and the future lawyer crazy and everything else trying to piece this together over 10 amendments or 2 amendments, even 1 amendment, because we want it to be where you can look at one document and the one document says what needs to be done and what's supposed to be done, rather than having to go back and forth between all these pages and have them spread out all over your desk. It can drive you crazy. And so that's the way that we do amendments to the trust, is we do restatements. Even if it's a small amendment, it's so much better to have it where, 10 years from now, we're going to look at it and it's still one document instead of having to try to combine multiple documents. So it's easily adaptable because we try to think of everything. It's easily adaptable because we try to make sure that everything is thought of it, and we've thought of the what ifs. But secondly, it's easy and adaptable because we can change it. We can make the changes whenever you have changes, or that we recommend changes because of law changes or things like that. I have a bonus one. Here's my bonus reason. So I told you 3, but I'm giving you 4. Here's my bonus reason. Well, there was a big change in the law last year with regard to IRAs and 401ks. So with IRAs or 401ks, there's some tax advantages to those accounts. So even Roths, for example, if you have a Roth IRA, there's tax advantages. Now the trust can help us have the flexibility to get better tax advantages for the kids, sometimes for you, but also specifically for who you leave behind. Because ultimately the taxes are going to have to be paid on that, or we're going to lose the tax advantages of the Roth. If we have a Roth IRA, we're not going to be able to keep those forever. The IRS says, okay, those are going to end at some point. And with a traditional IRA or 401k, that means we're going to have to pay the taxes at some point. With a Roth, it means we're going to stop getting the tax advantages of the Roth at some point. But it's very, very important to be strategic about when and how we do that, when and how we pay the taxes with the traditional accounts, and when and how we give up the benefits of the Roth. And the trust is so much better positioned to make sure that the kids are going to be able to get that good advice, have the flexibility to make the right decisions that aren't going to be always obvious there, or even sometimes possible when it comes to just beneficiary designations. So something we do in our office, again, a lot of lawyers don't do this. A lot of lawyers will have you keep your IRAs and 401ks and Roths where they never interact with the trust. Well, that's because their trust, the way they write their trust, doesn't have the tax provisions in there. Ours not only has the tax provisions, but we've now updated it for this new tax law that came about in 2020 that gives us actually more flexibility to help us make sure that the kids and the family makes the right tax decisions to pay the least amount of taxes. So this is a real good bonus reason as to why that's a good tax savings. Wanted to point out a couple quick issues. One of the things why it's really helpful to have a trust is if there's any form of dementia. Not sometimes after the diagnosis, but ideally before the diagnosis, right? Because if it turns out that somebody has dementia before they die, it's going to be so much easier for the family to step in and help out if we have things situated properly and organized in a trust. And then I just want to do a real quick recap. We could talk a lot about the trust, but when I say a trust package or a will package, we're often talking about all of these things: a financial power of attorney, a healthcare proxy, the trust, a will. We still need a will even when we have a trust, but the will tends to be a backup, or what they call a pour over. And then we want to discuss asset protection, make sure we have a plan in place to protect things in the event of a nursing home stay or something like that. So that's a good amount of information. And if you have any questions, you can type in the questions, or Savannah's going to be able to come on here in a second, and she's going to give you some instructions about how to get your questions answered, or more ideally, come in and see us. Or, we do virtual appointments, phone appointments, online appointments, or face-to-face appointments. And the best way is, of course, to come and see us, and we'll make sure everything is set up for you. But if you just have a quick question, we've got ways to deal with that real quick and easy and fast and free. So we have that option too. And Savannah's going to step in and give you those instructions.
Thanks, Bob. And thanks everybody else for joining us today. As Bob mentioned, we do have a couple of easy ways for you to contact our team. Of course, you can always give us a call. We have an 800 number, which is 1-800-990-6030. You can also call us at our normal line, which is 810-694-9000. Same people answer no matter which number you call. And then we also have a link that you can click. I've just put this in the chat box. If you click the link, it will take you to a calendar, and you can choose a day and a time when a member of our team can give you a call. So these calls are a great opportunity for you to ask us any quick questions. We can ask you questions about your situation. And then if everyone decides it's the best thing, you can schedule an appointment with our legal team. So we are here for you. Again, 810-694-9000, or you can click that link. You also will be getting an email in the next few minutes that will have that same link and our phone number. You can always just reply to the email as well. And then we can start the conversation that way. So thanks again for joining us today, and we look forward to spending the day with you again next week. Bye-bye now.